Okay, welcome back. This is episode 2 for week 1 of Conlo 1. I still have Lainey here. She's behaving herself, so that's nice. Okay, let's talk about that Quinnipiac Law Review article. Some of the examples I'll use in this video are examples that are in the article. Let's talk about it. So as I mentioned in the last video, in constitutional law, there are different kinds of tests. They're not, you're not always dealing with here are the elements of, right? And we're going to talk here about why. Why would courts, craft these different types of tests? Make our jobs more complicated. When you look at elements-driven tests, right? Ask yourself, why would a court insist on elements, right? Take for example criminal law. Crimes have elements, right? And you know from criminal law that if somebody's charged with a crime, the prosecutor has to prove every element of the crime, right? No element can be left out. Why do that, right? I would ask, does that sound to you like a flexible formulation, right? A kind of wishy-washy thing, or does it sound pretty rigid, pretty stern, pretty exacting? And of course, the issue with the answer is the latter, right? And that's by design. Courts tend to insist that elements be met when something big is at stake, right? Somebody's fortune, somebody's life, somebody's freedom, right? Somebody's when I say fortune, money. Right, so if we're going to hold somebody liable or we're going to find somebody guilty, depending whether it's civil case or criminal, right? Oftentimes, we're going to insist that the elements of the contract were met, or the elements of the tort have been met, or the elements of the crime have been met. These are rigid tests, and they're rigid for a reason because there's a lot at stake, right? And we're usually talking about somebody having to lose something, right? Okay. Now, what happens if we're in a situation where a court, let's say the U.S. Supreme Court, wants to allow itself flexibility in future cases? You have to remember, the U.S. Supreme Court, or you have to understand, right, if you didn't know, the U.S. Supreme Court only hears the cases it wants to hear, for the most part. And we'll talk more about that later. And it only hears about 80 cases a year. That's roughly where we're at. So I don't think a lot of people know that, right? They don't hear that many cases compared to most courts. So they're hearing cases, right, that they're interested in hearing, and they're generally setting the rules for themselves, right, in future cases. Now, of course, they're also setting the rules for lower courts, again, to the extent that they can be understood. But when you have a court at the level of the U.S. Supreme Court that's hearing big cases and trying to set precedent for future cases, the court is going to want to allow itself quite a bit of wiggle room, right, or you might call it weasel room in some cases, in future cases. So they don't really like elements. Elements paint you into a corner, right? And besides that, a lot of the constitutional cases we're going to be talking about, it's nobody's life is at stake, nobody's losing their fortune, right? It's basically just the court deciding whether a certain practice is constitutional or not, whether the government can keep doing it or whether the government should stop doing it, right? So there are different kinds of cases. That being so, the Supreme Court often prefers factors to elements, right? And the way factors work would be this, right? We're going to look at the following 4 things, right? We will consider, watch for that kind of language, right? In determining X, the court will consider 1, 2, 3, and 4, right? So look what I didn't say there. I didn't say that in determining X, what one party must establish 1, 2, 3, and 4. I said in making a decision, a court will consider 1, 2, 3, and 4. That means you look at all of them, right? Or at least the ones that are relevant and in play, given the fact pattern. But no one is outcome determinative, right? So some of the examples that I've been throwing around, right, and some of these might be in the article, I can't even remember, but elements go like this. And think of, I'm going to often use this metaphor, parent-child, because in constitutional law cases, it's often the Supreme Court is the parent and the government, right, whatever government as at issue is the child, right? There's a parent-child relationship. So think of a parent-child relationship when you say to a kid, or if you're not a parent, when your parent said to you, whatever, okay, you will apologize to your sibling, you will do it right now, you will sound like you mean it, and you will promise never to do it again. So what did I just lay out? Think about that for a second, right? Correct. Those are elements. How do I know they're elements? Because I've given the kid, right, several things to do. I can't remember how many now. But, right, and everyone, it sounds to me like we're not messing around, right? We're being rigid here. Every one of these must be met. So that's an elemental, right, requirement or test. On the other hand, let's say that your kid wants to go to Disneyland, right, next summer. And you want to allow yourself some flexibility. See how this works, right? You're not going to make any promises, right? But you want to give the kid some guidelines about maybe, you know, how the kid could get to Disneyland next summer. So you say what? Well, okay, in deciding whether you get to Disneyland right in the next summer, I will consider, right, your grades, whether your grades went up or down, whether you did, you did a good job doing your chores, how you treated your siblings, right, and whether you got good reports on your behavior from school, right? I'll look at those things to decide whether we're going to Disneyland next summer. Okay, I didn't say you have to do 1, 2, and 1 and 2 and 3 and 4, right? I said I will look at 1 and 2 and 3 and 4, or however many, right, factors there are. So that would be more of a factors test. So I hope you see the difference there. It's less rigid, it's more flexible, it gives you wiggle room, weasel room, right, whatever kind of room you want in future cases. This can drive students nuts because what we want, and I think we're conditioned this way in our culture, is we want the answer, right? What is the right answer? And I say this all the time, right? There is no right answer in constitutional law in many, many cases, right? There's the answer that gets 5 votes on the Supreme Court, and there's the answer that gets 4 votes on the Supreme Court. So you see how that works? We don't beat our heads against the wall trying to figure out how a factors test is going to come out because it's hard to know. You just have to know what the factors are and how to work with them, right? So we'll obviously be talking about those as we hit factors tests as we move along. Next categories, right? Sometimes, instead of saying you need 1 and 2 and 3, sometimes a court says you need 1 or 2 or 3, right? So that's a categorical test, right? Where that often happens when a court takes a look back historically and says, okay, we're looking at how an area of law has developed, and we've seen that that we reach result X if the case fits this, or fits this, or fits this, right? By the way, incidentally, I mean, you can have a one category test, right? Like no parking. That's categorical, right? It just says no parking here, right? So if you fit in the category of parked, okay, so right, if you fit in the category of parked here, you've violated the rule. But so categories are like that, right? Either it's just one category, but oftentimes there's multiple categories where it's not and, it's or. Now think about how serious of a mistake it would be. That's why I emphasize this stuff. To misstate that on an exam or in practice, right? If you've got a Supreme Court case that says you need 1 or 2 or 3, you go into a courtroom and tell a judge you need 1 and 2 and 3. How much trouble are you going to be in, right? Well, a lot of trouble. That's a misrepresentation, a complete legal, a serious legal misrepresentation. So you can't do that in a courtroom, and you cannot do that on an exam. That's why I'm stressing this stuff, right? Get ready, get comfortable, right, with these tests. They have components, right? They break down into parts, but they're different types of tests. So elements is one type, factors another type, categories a third type. This one I usually joke around in class and say that I've seen my sister do this because I don't have kids, but I have nephews, and every time I eat with them, I'll see a little negotiation going on, like, Mom, can I be excused from the table? You can be excused. How many parents out there are laughing now? You can be excused if you eat 1 more carrot, or you take a sip of milk, right? Or I don't know, something else, whatever it is. Well, okay, so they're the kids. See, we learn this at an early age, right? The kid knows those are categories, right? I can pick one, right? I don't need to do all 3. Okay, next up, let's talk balancing tests. Balancing tests, think about, again, the parent-child metaphor. You have 1 bike, right, 1 bicycle, and 2 kids, and both of the kids want to use the bike. What would you ask, right? And by the way, when I throw these questions out, always feel free to pause and kind of think about it. Right, what would you ask under those circumstances, right? Neither one has a superior claim to the bike, right? Both are equally entitled to the bike under most circumstances. It just so happens at this point, both of them want the bike at the same time. So most parents would then ask, well, why do you want the bike, right? You know, I'm not applying elements here. I'm not applying factors here. I've just got two competing parties, right? And it seems like each of them has an interest. And we're in a situation where I'm not highly suspicious about anything or anything. I just want to know who has the better right argument. One kid says, I want to go to Joey's house and play video games. The other kid says, I have to do my paper route. Right. Well, okay. We do balancing. And you see who has the better argument, the stronger argument, and that's the party who wins. So there are different kinds of balancing tests that I want to go too nuanced in this video, but that's the idea behind balancing tests. So you have elements when you want to be rigid, categories when you're kind of doing a look back and trying to see where things fit, factors when you're trying to give yourself a lot of flexibility and wiggle room, and balancing when you're just trying to see who has the stronger argument. Finally, there's this kind of test that's very common in constitutional law called a means-ends test. And these are typically applied, you know, again, I'm generalizing here. There's a lot of nuance to this, but play along for a minute. We usually get to means-ends tests really in earnest when a judge is very suspicious and applies something called heightened scrutiny, right? And so how does this work with a kid? You walk into the kitchen and your child has emptied all of the ingredients to dinner, which you had nicely laid out on the kitchen counter, right? Has emptied all of them from their packaging onto the counter, including the eggs and the flour, right? You walk into this scene and you say, what on earth are you doing, right? What do you think you're doing? And you're going to probably get the kid answer back, right? Well, I was just trying to help. How many times have you heard that? I was just trying to help, right? Then you're going to apply a means-ends test, right? So if the kid says, I was trying to help, you're going to look at the means that the kid chose to do that, allegedly, right? Which was empty all of the ingredients, including the flour and the eggs, onto the kitchen counter. And what you're probably going to conclude is that if the kid was really trying to help, this was not the way to do it. That's a means-ends test. We do these things in our lives, right, everyday lives, without even thinking about it. When you say the way you tried, the way that you tried to do something doesn't match what you were trying to do, what you're saying is you failed a means-ends test. Courts do the same thing when they are suspicious, right? They look at whether the means that you've chosen match up with what you say you're trying to do. There are, again, different levels of means-ends tests. We'll do a deep dive into those throughout the term, and especially through Con Law 2 as well. But that's where we are. Okay, so in terms of, just to kind of wrap this up, right? You can expect in constitutional law not just to deal with elements, but to deal with factors, categories, balancing, means-ends tests as well. I'm sure there are other kinds of tests too, but those are the 5 that we're really focusing on. So each one of those has components. Each one of those breaks into if-then propositions, right? That's the way legal reasoning works. We'll talk about that as much as we can throughout the term, legal reasoning, and so you need to be prepared to deal with any one of those. Okay, so that's enough for this video. As always, stay safe, stay tuned, and I'll get another video up in the next couple days.